Yep, we can go live.
Mandy, it seems almost criminal that you are in the United States and we're not doing tag time together. I know it's a big country and you're in a different city, but still.
It's wrong, isn't it? Because we've had 2 opportunities for this so far, and we just haven't been in the same place. But I think next week could be our week.
Huzzah!
The season 6 finale will finally be in the same room, hopefully.
That's the goal. That's the goal.
Unless you're going to be in Prague or somewhere. So
I hope I'm not in Prague.
If you're not in Prague.
Let me rephrase. I would always be happy to be in Prague, but I would like some notice before going to Prague.
Before you end up in, I imagine it is rather challenging to just suddenly find yourself in Prague, as if, rather unexpectedly.
Right.
All right, then, let us begin. If everybody's sitting comfortably, let us begin.
Gather your popcorns, folks. There's something interesting going to happen at the end of today's episode.
Dun, dun.
Da-da-da! Greetings, everybody. We're back. Welcome to Delos Disputes Tag Time Season 6. We hope everybody's safe and healthy. No COVID, no flu, no bird flu. Whatever variant is doing the rounds, we hope you're safe. We're delighted you can join us. I'm your host, Kabir Degal, joined by my fabulous co-host, Amanda Lee, as her dentist calls her, or Mandy, as everybody else does. Chris, Mandy and I spent a lot of time coming up with our tag time gesture, and we decided to be party people and raise the roof. So we begin every episode raising the roof.
Hey, thank you.
We love it when our guests do that.
Yes.
A little bit on tag time. During this webinar series, we have leaders from all around the world joining us to engage in a discussion on a substantive topic on international arbitration. You, our audience, can ask questions. And then we're going to do something new. I'm really building the suspense up. And folks, as you can tell, we're so cool. We're on YouTube. So you can watch unpacking videos, you can watch advertisements, and you can learn about arbitration, multi-purpose. Mandy, one of the big developments in arbitration, right, and its evolution is really the ability of a tribunal to order interim or provisional relief, right? That really changed the way arbitrations used to be conducted. You could really distance yourself to the extent you want from judicial processes by going before a tribunal and having a tribunal look at your claim for interim relief. And that begs the question, right? How does the enforcement of interim measures work? What is the theory underlining that? What are recent trends? Truly a fascinating topic, and one that has so much for us to think about in international arbitration, right? Courts or judges, tribunals or arbitrators, all these fascinating interplay. And we have somebody who really has done it all, going to talk to us about it. Professor Dr. Boog is going to share his insights on this topic. Mandy's going to have the privilege to introduce our speaker, but just wanted to thank you very much for taking your time to join us today. Today's episode is co-sponsored by AFIA, ArbitralWomen, Arbitrator Intelligence, the Chartered Institute of Arbitrators, the Cairo Regional Center for International Commercial Arbitration Center, the New York International Arbitration Center, Racial Equality for Arbitration Lawyers, REAL, LONDAP, and of course, these awesome initiatives by our own Mandy, Careers in Arbitration and Our Balance. Check them out, folks. If you are, like most lawyers, feeling the pressure of practice, Our Balance, the one-stop shop for everything to help take away some of these issues. Let me just talk a little bit more about the process and what you can expect. Mandy is very soon going to introduce our fabulous speaker, who will then talk to us for about 40-45 minutes on this fascinating topic, one that I'm really interested in myself. You, our audience, can then ask us questions. If you have a question, get your pens ready, folks. Email us, tagtime@delosdr.org. Mandy, I'm playing with you. I'm trying to change it up, and it's throwing you off. tagtime@delosdr.org. And let's just offer our best practices for questions and answers. Tip number 1, a question is a question when it ends with a question mark. Please don't give us sentences. We don't know what to do with that. Point number 2, to help Mandy and me, really keep your question to 3 lines or under. It really facilitates us reading them out better. And point number 3, when you have speakers who are prominent arbitrators, as is the case today, the temptation to go beyond what is spoken and potentially into areas where the arbitrator is presiding may be high. Resist the temptation. We don't want to abuse the prerogative of busy people giving us time. And so please respect that. With that, Chris, very, very grateful you could join us. And I'm going to pause here and pass the proverbial mic to Mandy to do the very tough task of introducing our speaker. Mandy, take it away.
Thank you very much, Kabir. As always, I have the pleasure of introducing today's guest. Dr. Christopher Boog is Vice Chair of the International Arbitration Practice Group at Schellenberg Whitmer and the Managing Director of the firm's Singapore office. He splits his time between Zurich and Singapore, where he's joining us from today. Chris represents clients in complex international commercial, investment, and sports arbitrations, and sits as arbitrator in civil and common law jurisdictions around the world under all leading arbitration rules. Chris is ranked as one of a small number of global elite thought leaders by Who's Who Legal Arbitration and serves as a vice president of the Court of the Swiss Arbitration Center. He was the 2020 recipient of the ASA Prize for Advocacy in International Commercial Arbitration, awarded every 2 years to International Arbitration Council to recognize exceptional advocacy. Please try to resist the urge to ask him for his top tips on advocacy. We may struggle to resist that urge ourselves, but we'll see. He was tagged by Giselle Nutz. We are very honored to welcome him to Tag Time today. And so without further ado, Chris, the floor is yours.
Thank you so much, Mandy. Thank you very much for your kind words. Thank you also, Kabir, for your very kind introduction. Greetings, everyone, wherever you are. Pleasure to be with you today. And thank you very much, Delos, for having me. And last but not least, as Mandy mentioned, thank you, Gisela Knutz, for tagging me and for putting me in the hot seat, as Mandy likes to refer to it, or has referred to it in previous sessions. So when I was asked to do this, the brief was, as I think Kabir mentioned in his introduction, to speak on a substantive international arbitration topic. I'll be very happy to oblige, especially in times where I think we often limit ourselves to speaking more about best practices and war stories. So with that brief, of course, I started thinking about which topic I could address, and for inspiration and also to make sure that my topic had not already been addressed, I went back to previous seasons of this series, and I saw that I think it was almost exactly a year ago in season 4, Philippe Vincent spoke on the topic of when interim measures can be outcome decisive and why. And in his presentation, Philippe set out why interim measures are today a crucial tool in international arbitration, be it investment treaty or commercial. And I think the same can also be said for sports arbitration, where some might say that interim relief is even more crucial. Now, Philippe highlighted, among other things, that we have been seeing an inflation of interim measures in recent years. And I think it's safe to say that in the challenging times we are currently living in, we are and will be, if anything, seeing requests for interim relief become even more frequent and important. And then in that episode with Philippe, Kabir, you, I think, mentioned that Professor George Berman had also recently spoken substantially on the topic of interim relief. And with that, the topic of my presentation was fixed, because many years ago, I wrote my PhD thesis on the topic of the enforcement of interim measures in international arbitration. And a large part of that thesis was, in fact, written during my time as a visiting scholar at Columbia, where Professor Berman was my supervisor. So I, at least, am coming full circle here today, so to speak. So the topic of my presentation, as Kabir said, is the enforcement of interim measures, theory and recent practice. I'll spend the first few minutes outlining some basic principles so that we're all on the same page as to what we are talking about. I'll then discuss some selected theoretical issues that are often reflected in practice, and I'll conclude by outlining some more recent examples from international case law to demonstrate that what I am talking about is not purely theoretical, but indeed very practical. So let me start by setting the scene and giving you some basics in 5 points. My first point is that it is nowadays universally acknowledged that, of course, unless the parties have expressly agreed otherwise, arbitral tribunals have the power to order interim relief. As Kabir mentioned in his introduction, that was not always the case. But today there are only very few jurisdictions that still do not accept that arbitral power. This general acceptance of arbitral power is reflected in the UNCITRAL model law, in the vast majority of arbitration laws around the globe, as well as in all leading sets of arbitration rules. My second point is that the types of measures an arbitral tribunal may order are generally very broad. While some arbitration laws and rules expressly provide for a wide array of types of measures, such as, for example, the UNCITRAL arbitration rules or the LCIA rules, many others leave it to the tribunal's full discretion. We take, for example, the ICC rules. Those provide that the arbitral tribunal may, at the request of a party, order any interim or conservatory measure it deems appropriate. Now, in practice, this means that interim measures can include a very vast array of different measures, including measures enjoining a party from doing something like drawing a bank guarantee or disposing of assets, measures ordering interim performance of an obligation like payment of a milestone payment under a contract, or undertaking any other type of action, such as, for example, withdrawing a criminal complaint, but also measures to preserve evidence or payment of a security for cost, to give you just some examples. My third point is that the same applies to the criteria which the tribunal shall apply to decide on a request for interim measures. Some rules and laws provide for specific criteria, but most do not. And best practice today, absent any express agreement by the parties to the contrary, or any express criteria in the lex arbitri or the arbitration rules, is for the tribunal to apply a balance of convenience or balance of interest test. Fourth, it is commonly accepted that state courts at the seat of arbitration or elsewhere have parallel jurisdiction to issue interim relief in support of arbitration, and that jurisdiction can be concurrent or sometimes subsidiary in the sense that it is limited to special circumstances, especially once the tribunal is in place and in a position to render interim relief itself. An example here again are the ICC rules, which provide that before the file is transmitted to the tribunal, and in appropriate circumstances, even thereafter, the parties may apply to any competent judicial authority for interim or conservatory measures. And my fifth point of introduction is that in many cases today, depending on the arbitration agreement, the parties will have the option of seeking interim relief from an emergency arbitrator prior to the constitution of the arbitral tribunal proper. So in sum, as a starting point, when we talk about the enforcement of interim measures in the context of international arbitration, we are in fact talking about a whole array of sub-issues, including the enforcement of measures ordered by arbitral tribunals, the enforcement of measures ordered by state courts in support of arbitration, the enforcement of measures ordered by an emergency arbitrator, as well as the enforcement of a whole array of different types of measures, both in terms of their content, their effects, but also in terms of their scope. And as much as I'd love to, I'm afraid I will not have the time to address all of these issues in the 40 to 45 minutes I have today. What I would like to focus on today are some key points in relation to the enforcement of measures ordered by emergency arbitrators and by arbitral tribunals. The first of those is whether there is actually even a need for the enforcement of interim measures in international arbitration. The reason I say that is because we hear time and time again that there is not, because parties comply with interim measures voluntarily for fear of anything from adverse inferences to making a bad impression on the tribunal in case they do not comply, or even dismissal of their case on the merits. And indeed, empirical data shows that this is to some extent correct. So if we take a look, for instance, at the ICC Commission report on emergency arbitrator proceedings, it is reported there, and I quote, that the data suggests that in the vast majority of cases, parties comply voluntarily with EA decisions. And of course, this applies even more so regarding interim measures ordered by an arbitral tribunal, in other words, the same decision maker that will also be deciding on the merits of the case. However, and this is important, this will not always be the case. A party may rather indeed have an overriding interest in non-compliance. And the cases we will be discussing at the end of this presentation shows that non-compliance indeed happens in practice. So for example, if a party confronted with a freezing order in breach of the interim measure is able to move its assets outside of the reach of the opposing party, it will probably no longer fear any negative impact of its non-compliance on the merits of the case. But even I think where this is not the case, a party in whose favor the interim measure was ordered may have an interest in enforcing it before it knows whether its opponent will comply voluntarily or not. So imagine you have obtained an order, say, from a tribunal, say, preventing your opposing party from disposing of an airplane. You know that that airplane is currently located in a jurisdiction that allows for easy enforcement of interim measures. So you might then wish to have that order enforced immediately before the plane is moved out of reach of that jurisdiction, even if voluntary compliance with the measure is at that point in time still a possibility. So I think in all of those cases, it is indeed imperative that a party may seek enforcement of the measure ordered if it so either needs or desires. And I think this need for enforceable interim measures is generally recognized today, including, for instance, in the UNCITRAL documents, or also in the 2005 Queen Mary study, where it was indeed reflected that users of arbitration mentioned that the enforcement of interim measures by arbitral tribunals was one of their main concerns. The second point I wanted to address is if and how interim measures granted by arbitral tribunals can be enforced if need be. And the good news up front is such measures are widely enforceable these days, although I must also state that there are still some outlier jurisdictions that seem to be quite reluctant to enforce tribunal-ordered interim measures, at least where the tribunal is seated abroad. Now, the easiest way of achieving enforcement is, of course, if the law expressly provides for the enforcement of tribunal-ordered interim measures, and many laws these days do. So under the provisions, for example, of the UNCITRAL model law, at least in its 2006 version, tribunal-ordered interim measures are expressly enforceable under Article 17H, which provides that any measure issued by a tribunal shall be recognized as binding and enforced upon application to the competent court, irrespective of the country in which it was issued. Some jurisdictions which have not implemented the 2006 amendments to the model law or are not model law jurisdictions at all, nevertheless contain express provisions in their arbitration laws providing for the enforcement of tribunal-ordered interim measures. Examples here are Switzerland or Germany or Austria. Now, these types of provisions will normally apply irrespective of whether the interim measure has been ordered in the form of an order or as an award. Most rules, as you know, grant the tribunal discretion to that effect. And when it comes to enforceability, most courts will apply a substance over form approach, looking not so much at the form in which the decision was rendered, but rather the substance of the decision contained therein. But you will see later on when we go into some of the examples that that is by no means always the case. Now, where it becomes trickier is where the applicable laws at the place of enforcement do not include such enforcement provisions specifically for tribunal-ordered interim measures, such as is, for instance, the case in the US. And the question then arises whether interim measures are enforceable under the New York Convention. Now, the correct answer, in my view, which thankfully is shared by others, is no. And the main reason being that interim measures, irrespective of the form in which they are ordered, do not qualify as an award in terms of the New York Convention. This is important, in terms of the New York Convention, and a teleological or purposive interpretation of the New York Convention to expand the meaning of the term award is not permissible under the Vienna Convention on the Law of Treaties. I address this point in quite some detail in my thesis. I don't have time to go through all of that, but to summarize in one sentence, since at the time of conclusion of the New York Convention, it wasn't even accepted that arbitral tribunals had the power to order interim measures, the term award in the New York Convention cannot be expanded by means of interpretation to include interim measures, especially since such interpretation would, of course, not only render it possible to enforce interim measures under the convention, but would also impose an obligation on the member states to do so. And such an obligation was clearly not envisaged when the convention was entered into. I think still the best case law, at least that I'm aware of, in support of this position to date, is a case by the Supreme Court of Queensland, Australia, from I think it was 1993, in resort condominiums, where the court reasoned quite extensively and correctly, in my view, that the New York Convention does not apply to interim measures. But there is, of course, also ample case law, especially out of the US, to the contrary, at least where the measure was rendered in the form of an award. So here the form can indeed be decisive as to whether or not an interim measure can be enforced. But those decisions, and I say this with respect, appear to be more guided by a practical need than a really sound legal reasoning. But I will say that the courts are to be commended, at least for their arbitration-friendly stance and their acknowledgement of a need for enforceable interim relief in international arbitration. And it is probably for that reason that US case law on this issue is often referred to as being pragmatic. I think this pragmatism is reflected also in the Restatement Third, where an arbitral award is defined expressly now to include a decision on interim relief to ensure the enforcement of interim measures. And I'm sure Professor Berman had his hand in making sure that that was the case. But again, in sum on this point, the good news is, one way or another, tribunal-ordered interim measures are very often going to be enforceable today, be it at the seat of arbitration or even cross-border. Now, kind of as a side note, what happens if the measure ordered by the tribunal is unknown under the laws applicable at the place of enforcement? So, for example, the tribunal has granted a more common law style freezing order, but the law at the place of enforcement of that measure does not know freezing orders or injunctions, but only more civil law style attachments. Well, in such cases, it may be that the tribunal ordered measure is not enforceable in that jurisdiction. However, instead of simply denying enforcement of a measure that is not known under its lex fori, the enforcement court in many jurisdictions will have the power to so-called transform or adapt the unknown tribunal-ordered interim measure into a measure that is known under its own law, so as to render it enforceable in accordance with its purpose. This concept was also addressed by the drafters of the 2006 model law amendments and is reflected in Article 17I of the model law, which provides that recognition or enforcement of an interim measure may be refused only if the court finds that the interim measure is incompatible with the powers conferred upon the court. And here comes the important part: unless the court decides to reformulate the interim measure to the extent necessary to adapt it to its own powers and procedures for the purposes of enforcing that interim measure and without modifying its substance. And you will find similar modes of transformation in the laws and case laws of many other jurisdictions, and they are indeed to be commended under the legal concept of favor recognitionis. The third point I wanted to address is whether, and if so, how interim measures ordered by emergency arbitrators are enforceable. And this is a bit of a thorny one and an issue that has been tackled in different ways by different legislators and courts around the world, and on which scholarly opinion still, I will say, differs quite significantly. The problem is that the issue is very rarely addressed in the law. So the New York Convention obviously does not address the emergency arbitrator, as the concept wasn't even known at the time the convention came into being. The model law doesn't address the emergency arbitrator at all, including, of course, enforceability of its decisions. Again, when the 2006 amendments of the model law came about, I think the ICDR and possibly the CPR rules were the only rules around the globe that had an emergency arbitrator. So it wasn't really a known concept or anything at the forefront of people's minds at the time. Even today, only very few national arbitration laws expressly provide for the enforceability of emergency arbitrator measures, including New Zealand, Hong Kong, and Singapore, just to give you 3 examples. And in those jurisdictions, as per the express terms of the law, emergency arbitrator decisions are enforceable, just like interim measures granted by arbitral tribunals. And finally, arbitration rules commonly provide that the emergency arbitrator's decision is binding on the parties, but little else, which of course is not surprising, since arbitration rules don't bind state courts or enforcement courts, and therefore cannot really make any binding statements as to the enforceability of decisions taken by emergency arbitrators. Now, The initial and really the crucial question in this regard is an emergency arbitrator an arbitrator? Because if the answer to that question is yes, then those provisions or that case law that apply to the enforcement of interim measures granted by arbitral tribunals will apply also to the emergency arbitrator's decisions, at least in many cases. And the answer to that question, again, in my humble opinion, is indeed yes. An emergency arbitrator is an arbitrator. An emergency arbitrator is a decision maker vested by the parties with the power to decide on their dispute, albeit that dispute being limited to whether or not the requested interim measure should be granted. The emergency arbitrator is subject to the same requirements as to independence and impartiality as any arbitrator is. And crucially, I think under practically all regimes, or at least the regimes I'm aware of, the emergency arbitrator's decision is binding on the parties. And it is binding not only in the contractual sense, such as, for example, a decision by an ICC pre-arbitral referee or a mediated settlement, but rather judicially binding, so to speak. The fact that the emergency arbitrator does not have the power to render a final decision on the merits of the case, in my view, is not decisive. They are charged with resolving in a binding, and for that purpose, also final matter, by the way, the parties' dispute on interim relief. And that is sufficient for the qualification of an emergency arbitrator as an arbitrator. This view, in fact, seems to be supported by what was the majority of national reports prepared in view of the ICC task force I mentioned earlier. And it also finds very helpful support in some sets of arbitration rules, such as the Swiss rules, the SIAC rules, or the LCIA rules, which expressly state that the emergency arbitrator is an arbitrator, or that the definition of an arbitral tribunal includes an emergency arbitrator. But be aware that there are still opposing views, so you will have to really check on a case-by-case basis what views are taken by the courts of the jurisdiction in which you are seeking enforcement. In other jurisdictions, emergency arbitrator decisions have again been enforced as awards under the New York Convention. Again, that applies predominantly in the United States, but not only. In those jurisdictions, therefore, it may indeed be important that the emergency arbitrator has the discretion under the applicable rules to render its decision in the form of an order or of an award. And that is the case under some rules, such as, for instance, again, the Swiss rules, the ICDR rules, or the SIAC rules, but it is not the case under other sets of rules, for example, the ICC rules or the recently revised NYIAC rules. So under those rules, depending on where you need to get your decision enforced, you may indeed be at somewhat of a disadvantage. So in summary on this point, emergency arbitrator measures are generally enforceable, but it will depend on where you are seeking enforcement. And I think when asked about the enforceability of emergency arbitrator decisions by probably you, Kabir, in his talk, Philippe Pinsol answered, try your luck. And I couldn't agree more. And I think increasingly you will probably get lucky and you will be able to enforce your emergency arbitrator decision. The final theoretical topic I'd like to address is ex parte interim measures, or preliminary measures or orders, as they are sometimes called. Another thorny one, and the common lawyers among you in particular may want to mute me for the next few minutes. What is the issue here? In some instances, and I think this part is uncontroversial, for interim relief to be truly meaningful, it has to be granted on an ex parte basis. And by that, I mean not only that a requested measure is granted before the opposing party has been heard, but also before the request has even been notified to the opposing party. Now, courts around the world have, of course, been doing this forever, acknowledging that need, and there doesn't seem to be much controversy about that. But some suggest that it is somehow improper in arbitration. And to be very frank, I fundamentally disagree with those views. I think so long as the opposing party is heard immediately after the initial order is made, and the tribunal or emergency arbitrator has the power to revisit its decision, there really is no reason to limit its power to grant ex parte interim relief, at least in exceptional circumstances. Again, I don't draw this opinion out of thin air. It indeed appears to be the increasingly acknowledged position. The model law, in fact, provides for preliminary orders, a form of ex parte relief in Article 17b. Modern institutional rules, such as the Swiss rules or the DIAC rules, the SIAC rules, and the DIS rules, also allow for ex parte relief, and tribunals are in fact granting such relief these days. The question then is, of course, are such ex parte orders immediately enforceable in national courts? And the answer here is very difficult. The model law expressly states that they are not enforceable. If you look at Article 17C, paragraph 5, which states a preliminary order shall be binding on the parties, but shall not be subject to enforcement by a court. Most national laws do not contain any express provisions allowing for the enforceability of ex parte measures. So where does that leave us? I think if voluntary compliance is not to be expected, if you need very urgent ex parte relief, you will probably, in many cases, be better off going directly to the state courts at the place of enforcement, if that is an option. And that's a big if, because in many cross-border situations, that will not be an option. So now all of this has been rather theoretical, and I promised you some practical examples of recent case law. So here we go. The first case I wanted to mention is one rendered by the Singapore High Court very recently, in fact, on the 22nd of October, 2022. Now, I mentioned earlier that the Singapore legislator has ensured that emergency arbitrator decisions rendered in Singapore are enforceable in Singapore by expanding the definition of what constitutes an arbitral tribunal to include the emergency arbitrator. So that part is uncontroversial. Now, in this recent decision, CVG versus CVH, the High Court decided that this applies equally to emergency arbitrator decisions rendered abroad. And in that case, it declared a US-seated ICDR emergency arbitration award generally enforceable in Singapore as a foreign award under the International Arbitration Act. This issue as to whether Singapore would enforce foreign emergency awards has often been debated because the amendments made to the Singapore International Arbitration Act in 2012, which amended the definition of arbitral tribunal to include the arbitrator, strictly or formally did not apply to Part 3 of the Act, which deals with the enforcement of foreign arbitral awards. The court now in this case rejected this stance. Instead, it considered that a purpose of interpretation, or under a purpose of interpretation, the term arbitral award in section 27(1) of the Act includes awards by emergency arbitrators. Now, interestingly, although the court found that in principle the decision is enforceable, enforcement was refused in this case for breach of natural justice. What had happened was that a party had sought to raise arguments after the hearing in the emergency arbitration to which the other side did not respond, and the Singapore court found that because the emergency arbitrator had considered those arguments, he had breached natural justice. The second case also relates to the enforcement of an emergency arbitrator decision, and this time in India in the matter of Amazon versus Future Retail. What happened in that case is that in 2020, Future Retail announced that it was selling assets to Reliance Industries, another Indian conglomerate. Amazon then commenced SIAC proceedings against Future Retail and at the same time applied for emergency measures, alleging that the planned transaction was in breach of a 2019 shareholders agreement by which it, Amazon, had acquired a 49% stake in Future Coupons, which had acted as a promoter for Future Retail. Now, finding that Amazon had a strong prima facie case, the emergency arbitrator indeed enjoined the respondents from taking further steps to complete the transaction. Amazon took this judgment to the courts and for enforcement, and in a judgment dated March 2021, the Delhi High Court enforced the emergency arbitrator's order. The High Court took the view that the emergency arbitrator qualified as an arbitrator under Indian law and that the emergency order was an arbitral order for interim measures enforceable under the Indian Arbitration and Conciliation Act. That decision was then subsequently set aside by the Indian Supreme Court in February of 2022. And interestingly, again, not because the Supreme Court disagreed that the emergency arbitrator order was per se unenforceable under Indian law, but because it found serious procedural errors in the emergency arbitrator proceedings. So similar to the decision in Singapore, whilst accepting enforceability in principle, the court ended up denying enforcement in casu for other reasons. The third decision is a case from the Netherlands. In a judgment dated September 2021, the Court of Appeal of The Hague refused to enforce an ICDR emergency arbitrator award against a company called Refineria di Corso, or RDK, which is Curaçao's state-owned refinery company. In this case, Venezuelan national oil and gas company PDVSA had commenced an ICDR arbitration against RDK in 2020 after having operated its refinery in Curaçao for more than 30 years. And the dispute pertained to PDVSA seizing operations of the refinery back in 2019, allegedly due to US sanctions against Venezuela. What RDK subsequently did, probably in retaliation at least to some extent, was apply to the local courts in Curaçao, claiming that PDVSA had failed to make lease payments and meet other obligations under a lease agreement. And the Curaçao court ended up ordering PDVSA to pay damages. So 2 months later, PDVSA obtained an award from an emergency arbitrator barring RDK from enforcing that Curaçao judgment against PDVSA's assets, and then sought to enforce the emergency arbitrator's decision in the Netherlands, kind of as a bar for enforcement of the Curaçao judgment. The Hague Court of Appeal refused to enforce the emergency arbitrator award, but again, not because it considered such an award non-enforceable per se, but rather because it found that the enforceability of the Curaçao judgment was an obstacle to the enforcement of the emergency arbitrator award, and the enforcement of a foreign judgment in the Netherlands could only be refused on the grounds set out in the law, of which the existence of an emergency arbitrator award was not one. The fourth decision worth mentioning in this context comes out of Ukraine. It is an example where a court found that an emergency arbitrator decision could not be enforced. The history was that in 2018, and you may have read about this in the press, Everest Estate and 18 other claimants had obtained an UNCITRAL award against Russia under the Russia-Ukraine BIT, ordering the latter to pay damages for expropriating real estate in Crimea. And in an attempt to enforce that award, the claimants attached shares of a Russian bank in a Ukrainian bank in Ukraine, and those shares were then put up for auction by the Ukrainian authorities for the proceeds to be used in satisfaction of the award. In response to all of that, the Russian bank commenced an SEC arbitration in Stockholm against Ukraine under the same BIT, alleging a range of discriminatory actions and at the same time applied for emergency relief. And in August 2019, the emergency arbitrator indeed directed Ukraine to refrain from selling the bank's shares pending the outcome of the Stockholm arbitration. The Russian bank then petitioned the Ukrainian court to enforce the emergency arbitration award. But, probably unsurprisingly, the Ukrainian courts refused, and the Supreme Court of Ukraine ultimately confirmed that the emergency award was contrary to public policy because it purportedly conflicted with previous Ukrainian court decisions permitting creditors of Russia to enforce against the bank's assets. So again, interestingly, enforcement was refused, but not because an emergency arbitrator's decision was found unenforceable as such, but rather for other reasons. I have two more cases that I wanted to mention that concern not emergency arbitrator decisions, but rather decisions on interim relief by an arbitral tribunal proper. The first relates to orders of the US Supreme Court for the state of New York in GE versus Crédit Agricole and Société Algérienne de Production de l'Électricité, or SPE for short. In that case, there was an arbitration commenced by GE in 2020, seated in Geneva, which arose from SPE's alleged failure to comply with a contract for the construction of a power plant in Algeria. And in the course of the arbitration, SPE requested banks to draw down bank guarantees, a request which the arbitral tribunal found to be wrongful. So it directed, by means of interim measures, SPE to withdraw the request and barred it from drawing or collecting upon the bank guarantees while the arbitration is pending. GE then sought to enforce those orders against the bank in New York, and per its orders of April 2022 and September 2022, the Supreme Court for the state of New York enforced the interim measures imposed by the ICC tribunal. And finally, also in relation to interim measures granted by an arbitral tribunal, let me mention a decision rendered in Egypt by the Cairo Court of Appeal in 2018. In that case, the Cairo Court of Appeal upheld the decision of a lower court to recognize and enforce interim measures issued by an ICC arbitral tribunal seated in Paris between a South Korean contractor and the developer of the Damietta port in northern Egypt. The tribunal had ordered there that the developer withdraw a request for payment of a bank guarantee and terminate Egyptian court proceedings it had initiated against the relevant bank. The Court of Appeal gave full effect to the first measure, and the court proceedings against the bank were subsequently suspended. And this is said to be the first case of an interim measure issued by a foreign tribunal to be enforced in Egypt. It's also said to fill what was previously a void in Egypt's arbitration law. What's also interesting is that on the level of scrutiny of the Court of Appeal held that the sole role of the court is to assess whether the tribunal complied with the procedural requirements under the 2006 model law in issuing the interim measure, and it expressly abstained from delving into the substance of the matter. So to conclude, I think it's safe to say that the issue of interim relief is an interesting one, and at times still a thorny one. Whilst legislation and case law continue to develop, there are questions that still remain open, and in some jurisdictions, quite frankly, more than in others. What is encouraging, though, is to see that jurisdictions around the world are not only accepting that tribunals and emergency arbitrators alike have the power to grant a wide array of interim measures, but that their courts are also increasingly willing to recognize and enforce such measures. But I think, as the case examples I mentioned show, where we do still have a way to go is in terms of the level of scrutiny the courts apply to such decisions. And by that, I mean scrutiny both in terms of reviewing the proceedings, as we saw, for example, in the Singaporean case, the Indian case, and the Ukrainian case, but also in terms of the substance of the measure which was granted. And I think there the Egyptian case is a very good example of a court saying we actually need to take a step back and refrain from looking at the substance of the case, just like we refrain from looking at the substance of an arbitral award when the enforcement of an arbitral award is sought, save, of course, for extreme cases of public policy or alike. But these, ladies and gentlemen, are topics for another day. For today, I'll conclude here so as to leave at least some time for questions, and thank you very much for your attention.
Well, thank you very much, Chris. That was a tour de force performance, and we're glad that you were able to build on your previous research, and it's always nice to be able to give Professor Bertman a shout out as well. So the Delos series on this topic is definitely coming full circle. Hopefully in the future we'll be able to get Professor Bertman to come and share his views as well, and then we can have a sort of a debate possibly.
Indeed.
Let me just take this opportunity to flag that the Delos rules, Article 12.4E2, actually provide for the possibility of ex parte interim measures. So that's always good to know, I think. Now, in terms of questions, my question for you is inspired by an English case, and this is a case called EGF and HVF and others. And in that case, the judge dismissed a challenge to an award under Section 68 of the Arbitration Act 1996. That's by way of background. However, he held obiter that the arbitrators had exceeded their powers by issuing an award for a merely interim remedy under Article 34 of the UNCITRAL rules. So basically, we've got a little bit of a debate here in terms of the form. So we would welcome your thoughts on the form of interim relief that parties should be seeking from tribunals if they want to avoid enforcement pitfalls when it comes to the form of this type of relief.
I think, as I mentioned before, many rules will expressly give the tribunal the power to choose. So the discretion to either render the decision in the form of an order or in the form of the award. So the problem arises where you don't have that type of express provision. Correctly, those decisions should be orders. So I would say the English judge wasn't wrong in his decision. I do think, though, that it is appropriate where they have the power either expressly or at least implied to issue an award for an arbitral tribunal to issue an interim award, because we still have those jurisdictions where it's just much easier to enforce an interim award than an interim order. But I think technically they should be orders.
Thank you. I think Section 39 of the English Arbitration Act hasn't really made things particularly easy for anyone by referring to both awards and orders. So thankfully, that's something that's been picked up by the Law Commission as part of its present review in any event. I'm mindful that we are now coming to the end. So unless Kabir has a question, and I don't believe he does, he might. I'm sure he has lots of questions he'd like to ask.
Have a lot, but we should be mindful it's very late for Chris. So.
Time grows short, and it is probably midnight by now, I think, with you, Chris, or nearly midnight.
I think it's almost 1 a.m.
Almost 1 a.m. Respect.
We're beyond my bedtime now. We could just keep going.
We'll just go all night now. This is going to be the longest ever episode. of TagTime. Well, Chris, thank you very much for taking the time to join us for TagTime today and for staying up well beyond your bedtime. We really do appreciate it.
It was a great pleasure. Thanks for having me.
We're very, very grateful. And as Kabir has said, there are lots of questions that we could ask you, but for the pesky time limitations. Now, as our audience will know, this is traditionally the part of the show in which we ask our guests to tag their successor in the, as mentioned earlier by Chris, hot seat, and to choose who we will be hearing from in a future episode of our show. However, today is the dawn of a new era of sorts. As we all know, tagging has many different meanings, ranging from tagging someone in a social media post, a photo, or an update to create a link between the two of you, to tagging by assigning a keyword or a phrase to something, or even tagging people in the playground, which we all probably did when we were kids. A tag can also be used for the identification of pets or cars, for example, or even in the context of adding something to a wider debate. So tagging your question or your comment onto the end of a discussion, for example. As you'll have seen from our promotional artwork, graffiti artists tag their art, with their tag representing a signature of sorts. And for our IT friends, a tag may even be an instruction that explains how text should be displayed or interpreted. So please tag along with us and stay tuned as we take TagTime to a whole new level and in a slightly different direction in 2023. So stay tuned, folks. Before that, though, we continue to look forward to featuring Olena Peripolenska on the show next week on December 7th for the final episode of Season 6. So we invite you all to stay tuned for what is to come next. To our audience, thank you for taking the time to join us, whether you're joining us live or you're joining us over the holiday period, during a quiet moment in your day job, who knows? Whenever you're joining us, we're glad to have you. If you registered for today's live episode, you'll receive a link to the recording of this webinar in due course, accessible for a limited time only, and thereafter via Delos's members area. And remember, you can always catch up with recent episodes of TagTime and other Delos programming on Delos's YouTube channel and otherwise via its member area. I believe we have a final coming up in the rope advocacy tournaments as well. So keep your eyes open and on social media for news about that. Until then, thank you once again to our fabulous guest, Chris. Thank you for staying up so late. We really appreciate it. We're very grateful for your insights. And thank you to, hey, we love it. Raising the roof, fabulous. Thank you all for joining us today. Please do stay safe, everyone. I'm pretty traumatized by the laundry list of potential ailments that Kabir gave us at the beginning. So I'm hoping that nobody is dealing with avian flu in particular. That one sounded pretty traumatic. So definitely stay safe and healthy, everyone. And I'll hand you over to Kabir to say his goodbye.
Thank you, Mandy. Let me just begin by saying, Chris, we take our proverbial hat off to you for staying up so late, for giving such an erudite presentation, but also giving such an elegant, articulate presentation. You know, Mandy and I were conferring, we can see why you got the advocacy prize. It was really a very enjoyable experience. And, you know, we really could keep you for a whole extra hour talking to you about this. We will not, but we will relay your presentation to Professor Berman because I think he will find this topic very fascinating. So thank you. To our audience, please. Send
my regards. Please do send my regards.
I definitely will. You know, both Mandy and I see him frequently. Mandy now because she's in the States, although she's in DC right now.
Thank you.
To our audience, stay safe, stay healthy, don't get the avian flu. If you get it, take care. And we look forward to seeing you for the final episode of Season 6. And I know everybody's in bated breath for what's going to happen in Season 7. Stay tuned, folks. With that, take care. Bye, everybody.